employee privacy rights. How much privacy does an employee have in the workplace? How much privacy do they have if they're actually working from home? How much privacy do they have if they have a company cell phone or a company computer? Does the employer have rights every time they use company equipment? Let's take a look at some of the different aspects of it. Employees do not have an absolute privacy in the workplace. They don't. No matter how anybody wants to spin it, even a fancy lawyer that is on top of their game, the aspect that they come in and say, well, that person had the right to sit down and talk privately on a cell phone. No, they don't. If they're in the workplace, they have a right to sit down and work. Everything that takes place in the workplace is work and underneath the employee's jurisdiction. And the employer in the process is over that employee. It's not a breach to employees' right of privacy for employer to ask them with whom they live. Okay, so the private sector, the Constitution doesn't protect the employee's right to be free from unreasonable searches and seizures. You can actually have somebody request to use your phone. One time I had a supervisor who was making unwanted advances towards a person of the opposite sex. He walked into the office, the human resource office, into one of my directors, and she had heard about it and she was investigating it. And she says, oh, you have so-and-so working with you. Yes, I do. Give me your cell phone. What? Give me your cell phone now. Why? He says, I want to look at it. So he hands her the cell phone. And she says, what's the passcode? He says, that's private. Do you use your cell phone, she says, for company business, and do you get paid an allowance every single month with your cell phone? I do. What's your number? She put the number in. She scanned his messages. Now, she didn't find messages that time. He ended up getting terminated for that offense about 3 months later when he got caught in another uncomfortable situation. But the reality is, frankly, I think she might have overstepped the aspect, except, okay, he's on company land, he's on company property, he's at another site soliciting sexual harassment, trying to get sex out of another person, another employee that is a subordinate of his, and texting her back and forth nonstop. So that being said, she was probably within her rights. I guess I prefer not to go to court over it, except for the fact that he was terminated for the offense later on. So that said, make certain you pay attention to what's going on. Employees are safeguarded to some extent by common law protections against invasions of privacy, but soon as you use a company computer, a company whatever, if the company owns it, they have a right to whatever is in the content of it. Send an email, if it's on the company server, boom, they have the right to look at it. If you want to order something on Amazon at the company that you work for, they have a right to know exactly what's on there. You don't have a right to privacy if you're in the company workspace. If you're using company equipment, you don't. The employee can give information to the employer, but the employer is bound to use that information only for the purpose it was collected, if indeed they're telling you exactly what it's about. So pay attention to this generally. There's no broad rights of personal workplace privacy. There is no reasonable expectation of privacy in the workplace locales. There could be zones of workday privacy. If you're talking to somebody on a confidential situation, you need to sit down and say, okay, here it is in the space over here. I'm talking to them about a problem. I want to be left alone. You can have a zone of workplace privacy, but I've had people come in and in my role of human resources, and they sat and said, okay, can I keep this between you and me? My response is no. If you tell me something that violates a board policy or violates law or a regulation, whether state or federal, I may be obligated by law to follow through on with different aspects of it. Just to make it clear, if somebody comes to you and you're in charge of employment law and they want to have a confidential dialogue with you, and all of a sudden they tell you about a rape they experienced last week on campus or on your workplace, okay, you then have to breach what you just told them. That is not confidential, and you will have a legal obligation to follow through in your capacity, whichever that may be, to make certain that whatever violation occurred, that you have to follow through and take care of that. Be careful. Don't make promises of confidentiality because you don't know what they're going to unload on you. So Otherwise, normally, if a zone of privacy, you shouldn't be searching anybody. You shouldn't be violating their physical space. You should pretty much leave their purse or their briefcase alone. Don't go through the wallet. Going through the phone was a bit overmuch, except for the fact it worked out fine. Okay, but make certain that you're looking on the instrumentalities. If it's an email, if it's a phone call, if it's records, if it's computer equipment, if those things belong to the company, then the company has the right to see what it is being used for. Make no bones about that. To search the actual employer-owned property, cloud storage from the work computer, the employee property, which could be backpacks, briefcases, purses, wallets. Sometimes you actually have to go through some type of scanner to get into your office. Then all of a sudden you're looking for that, but everybody's doing it, so that kind of changes the pattern. You may be put underneath the search if you're suspected for carrying things out. One of the very first jobs I had going through college, I worked in a factory. On the way out from the factory, everybody was required to open up their lunchbox, open up their thermos, and the security guards will actually check to make certain that nobody was stealing merchandise out of the factory because some of it was highly valuable. There's a forewarning and it's a consent. Pretty much it's a consent if you get the job that you sit down, and that's part of the overall aspect of it, and that's a procedure. However, being singled out changes the dynamics, although if they give you some type of claim as to this is what this is regarding to, you are obligated to sit down and submit to that search if it's on company property. The right to privacy, it's not absolute. The extent of protection varies on how much the intrusion is. If it's a physical body search, a cavity search, oh my gosh, heaven forbid that ever land in human resources. That's not something I'd be interested in doing. But anyhow, so that being said, interest of the employee, they're bound to get the interest of the employer. If the individual's interest in disclosure for information that's sought, okay, but if it's a matter of if you're trying to carry information that is owned by the company out into the public, then the employer does have a right to invade the personal privacy because of the fact that that might be some type of a leakage, some type of inappropriate aspect as to what that could be. The Electronic Communications Privacy Act, the ECPA, okay, it's not used very often, but it covers all forms of digital communication, not GPS, but you can actually figure that out if you wanted to actually, if it's a company car, if you're driving a company car, the company has a right to know where that car has been. If you're using a company phone, the employer has a right to see where that phone has been, if they can track it that way as well. This all includes transmissions of text, images, and so on, communications. It does prohibit unauthorized eavesdropping, but keep in mind, if you're using a company phone, then you have an issue to deal with. There's statutory claims in the private sector that recognize a constitutional for right of privacy under their state. Some states, for example, California, although California is not a very business-friendly state at all, so it is not necessarily the leading example of the rights of the employee or the employer, but protecting employees only in certain areas of employment, for instance, on personal records or use of credit information. That's a big deal. Now, if you have a company credit card, does the employer have a right to check your credit history? The answer is yes, it does. So if you have something in your personal life that overlaps with the employer's area, and if you're mandated to have a credit card or want to have a company credit card, it could have an effect as to what they're going to be looking at. So always pay attention to what's out there. There's tort law. You can always sue if you want to against a person or their property. If you as an employee want to publicize something that happened in the workplace, all of a sudden you can be subject to a tort yourself from the employer and termination. So privacy protections, intrusion into seclusion, make certain that in essence, the employer shouldn't sit down and pursue you in the privacy of your own sanctum, especially at home, publication of private information, publication that places another in a false light, or defamation. All those are always protected by common law and can be pursued in the court. Pay attention to all of them. Here, Lenore and Am Corporation, they hired a detective and gave the access to the former employee's phone records to track a non-compete compliance. Was that appropriate? By the time you're done, if somebody signed a document, does the employer have the right to pursue to ensure that document is pursued? And the answer is yes. So pay attention to all the different aspects of it. If it happens at work, the employer can review it. If it's done on a company device, the employer can see it. These are the realities that we have in the workplace when it regards to the realities of employee and privacy rights. Take care.